Well, good afternoon, everyone. I think I'll begin. Um, I'm Graham Webb. I'm a lawyer and the executive director of the Advocacy Center for the Elderly. And I'd like to thank everyone for attending our first session of the Town Hall series that we've developed. This is a very important step for our clinic to set our own agenda in terms of delivering public legal education materials. And I thank you so much for joining us. I'd like to, before we begin, offer a land acknowledgement. We commemorate the Indigenous people's principal kinship to the land, the fact that they have not and cannot be erased from her. We acknowledge that we, particularly the ACE offices in Toronto, sit on the traditional territory of many First Nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples. And it is now home to many diverse First Nations, Inuit and Métis peoples. We also acknowledge that the City of Toronto is covered by Treaty 13, signed with the Mississaugas of the Credit, and the Williams Treaties, signed with multiple Mississaugas and Chippewas bands. I'd like to speak very briefly about our own clinic. This is a photograph of our office at 2 Carleton Street, right above College Subway Station. The Advocacy Center for the Elderly is a community legal clinic under the Legal Aid Services Act. We were established in 1984. We're a nonprofit charitable corporation, and we're the only clinic in Ontario that exclusively specializes in legal services for older adults. Although I am glad to say that other clinics throughout Ontario, including the Northern Ontario Advocacy North Initiative and Eastern Ontario through the Renfrew Community Legal Clinic, also have specialized legal services. And we're finding that many other community legal clinics, including, for instance, Scarborough Community Legal Services, are offering more and more services directed towards older adults. And that's a trend we are very pleased to see. Our mandate is to provide summary telephone advice to people who call, to provide direct legal representation. We act as the lawyer for many older adults on legal matters that are related to age, where the older adult qualifies for our services by age, geography, income, and assets. To do work in the area of law reform and policy development, and also to provide community legal education, which is part of what we're doing today. Next slide, please. Our topic of legal strategies dealing with financial and property decisions really very much focuses on the prevention of financial elder abuse. This is a very important area of our work. We do a lot of recovery work, helping older adults to recover property that has been lost through abuse. And in the course of my work over the past 25 or 26 years with ACE is that I've found that financial abuse really focuses on power imbalances. You know, a more powerful person is somehow taking advantage of a less powerful person, where there's at least one, but usually more than one power differential that rests on age. It could be a sensory impairment, or it could be the need to rely on someone for transportation. It could be declining cognitive ability, which we'll talk about in great length, but in some way there's a power imbalance. And I've seen that older adults may either suddenly or gradually lose control of their finances. Even younger people, such as developmentally challenged adults who might age prematurely, may have a change in how they control their finances. And, you know, these changes in life, a death in the family, a medical event, may create a new financial arrangement that creates new power imbalances that invites financial abuse. That's the background to it. Next slide, please. There's been many studies on elder abuse. I don't plan to report on the numbers, but what I can say with certainty is that, elder abuse is underreported, and it often goes undetected and sometimes unrecognized. Of all the forms of abuse, financial abuse is the most common form of abuse. And I think the lesson, certainly for me, and I think my colleagues at the Advocacy Center for the Elderly, is that older adults should try wherever possible to maintain control over your own finances as long as reasonably possible. And, one of the things we'll talk about at length are powers of attorney. Powers of attorney are very powerful documents. They also give rise to an opportunity for financial abuse so profoundly that many authors have referred to a power of attorney for property as a, quote, license to steal. Of course, it's not legal to steal someone's money using a power of attorney, but it happens so often that it seems like it's a license to steal. Next slide, please. One thread that runs through financial abuse is a person's capacity to manage their own finances. And when we're speaking of capacity to manage finances, we're speaking of a legal definition. And this legal definition centers on a mental function. It doesn't matter if someone has sensory disabilities or physical disabilities. You might need someone else to help you to go to the bank. You might not be able to write a check by yourself, but your capacity to manage your own finances depends on your cognition and reason. And it also doesn't depend on age, because we get thousands of calls each year, and so often the calls revolve around a person's mental capacity. And one of the questions we might ask our caller is your mother, let's say, mentally capable? And the caller might answer, well, she is 87, And we didn't ask how old she is, because age is not a proxy for mental capacity. As long as you're over 18 years old, you're presumed to be mentally capable. And when it comes to the legal ability to manage your own finances, it is a legal test under Ontario law that has two components. The first component is the mental ability to understand information that's relative to a property decision. And the second is the mental ability to appreciate the reasonably foreseeable consequences of making or not making a decision. Making a bad financial decision does not mean that a person is mentally incapable. It simply means they made a bad decision. And if a person is uninformed about their finances because they've been denied access to their own financial information, that doesn't mean that they're mentally incapable of managing it. As long as they have the ability to understand the information, they have met that part of the test. And so we encourage people to continue to manage their own finances as long as they're able to do so. Next slide, please. One of the most popular ways of delegating authority to someone else to manage your finances is through a power of attorney for property, or a continuing power of attorney for property. And these are very, very powerful legal documents. In fact, they're one of only really three things that I can think of that under Ontario law or Canadian law have to be done in what we call solemn form. Solemn form means signed by the person giving it, in this case, the donor or grantor of the power of attorney, and by two witnesses both present at the same time. Another document that is usually done in solemn form, although it doesn't necessarily have to be so, is a will. This is the same way you do your last will and testament is in solemn form, signed by you in the presence of two witnesses who also sign in the presence of each other. And the third is actually getting married under the Marriage Act, where both spouses will sign a register in the presence of each other and in the presence of two witnesses who both sign at the same time. And, there's a lot of strong resemblances between giving a power of attorney for property or for personal care and to getting married. Because like getting married, if you're making a power of attorney, the person you're giving the power of attorney to must be somebody you really trust. If you're thinking of getting married and you can't decide if you trust that person, maybe it's not such a good idea to get married. Also, you don't need to get married. Lots of people live happy, healthy, and really rewarding lives without ever getting married. If you want to get married, go ahead and get married, but don't ever get married because you think you have to get married. And so too with powers of attorney. You never have to have a power of attorney. It's something that you can make if you think it's advisable. We recommend getting legal advice and understand what you're getting into. Like getting married, you should have a good idea what you're getting into before you give a power of attorney. And, like getting married, getting into a power of attorney can be easier than getting out of it. Because if someone gets married, they could say, well, if it doesn't work out, how hard is it to get out of this marriage? How hard is it to get a divorce? Well, it could be fairly easy if it's an uncontested divorce with no real financial issues and no children or support claims. But on the other hand, it could be very difficult and expensive to get out of an improvident marriage. And so too, it could be very difficult and expensive to get out of a power of attorney once you've given it. So these are decisions that are not to be made lightly. And what's most important is that powers of attorney give extensive legal powers over your financial for property, which we're talking about today, but as well your personal care decisions for personal care, powers of attorney for personal care, which my colleague Karen Stewart will speak about next week. Next slide, please. So when we're speaking specifically of a power of attorney for property, what we're talking about is the first of three methods that someone can delegate substitute decision-making power for property to another person. It's created when someone named a grantor or a donor names another person who's called an attorney for property in a power of attorney document. And the attorney is the person. Attorney here doesn't mean lawyer. It means your agent or the person you name to act on your behalf. And the power of attorney is actually the legal document that gives authority to your attorney. And the power of attorney document authorizes the attorney to make financial decisions on behalf of the person who gave it. And what many people do not understand, and I wish they would understand, is that the power of attorney document takes effect immediately, unless it says otherwise in the document. So if I give a power of attorney document to my son, that means as soon as I sign it, my son, I can still withdraw money from my bank account, and so can my son. And I could sell or mortgage my house, cash in my RRSP, collapse my life insurance policy, sell my car, and so could my son. These powers become immediately available once the power of attorney is signed, unless it says otherwise. And furthermore, if the power of attorney is a continuing power of attorney, which most powers of attorney in Ontario now are, it also continues in force even after the person who gave it loses mental capacity to manage their finances. Next slide, please. As with most things here, a lot turns on mental capacity. There is a test we just spoke of mental capacity to manage your own finances. It's stated by Ontario law. This test is a separate and distinct test of mental capacity to give or revoke a power of attorney for property. And I note the last bullet point on the slide, it does not depend on financial capacity. It says explicitly in Ontario law that a person could be mentally incapable of managing their own finances, but still fully mentally capable of giving or revoking a power of attorney for property. It's a separate test. And this test of capacity to give or revoke a power of attorney for property has these 7 elements. The first 5 relate to the person's knowledge of what a power of attorney is. It's understanding information about a power of attorney, knowing what your property consists of and its approximate value. It doesn't mean you have to know to the dollar what your net worth is, but if you say own a house and have money in the bank, and you maybe own a motor vehicle or some kind of investment, you should have some general knowledge of what it is that you own. You should be aware, if you have dependents, of what your obligations to your support obligations to your dependents are. If you have a dependent spouse or an adult son or daughter with a disability or someone else that you support. You should know what a power of attorney document does, that it allows the person you've named to do anything on your behalf except make a will with respect to your property. You should know that if you give a power of attorney, that person has the legal obligation to account to you. And you should know that if you give a power of attorney, as long as you're mentally capable to do so, you also can revoke or cancel it. And the test of capacity for giving or revoking is the same test. It is this test. And then the final 2 elements really turn on the appreciation of consequences. The first consequence is that if you give a power of attorney for property to someone who is not very good with money, they might be honest as the day is long, but they're a poor financial manager, then you stand the risk of property loss by reason of mismanagement. And second is the appreciation of financial abuse, that you must appreciate that if you give a power of attorney to someone, if that person abuses or misuses their powers, then you could also stand to lose property by reason of intentional or fraudulent actions. Next slide, please. And here we speak about springing powers of attorney. This is a very common term in the United States, less so in Canada. It's gaining traction. This is what's known under Ontario law as a condition of delayed effectiveness. And it's something, I don't draw many powers of attorney, but when I do, I almost always recommend a condition of delayed effectiveness, unless the person intends that the power of attorney would still be used while they're mentally capable of making their own decisions. And so a lawyer preparing a power of attorney can write in a condition that says, this power of attorney comes into effect only if and when a certain event occurs. In this case, if and when the person becomes mentally incapable of managing their finances. Over the 21 years that I worked as a staff litigation lawyer at the Advocacy Center for the Elderly, I handled many, many cases where our older adult client had been the subject of financial abuse at the hands of what we call a rogue attorney. And so often that person had no idea that the power of attorney took effect right away, and that the attorney would have immediate access to their funds and to their property. Next slide, please. When drawing a power of attorney, it's also available to make joint attorneys, and joint attorneys means multiple attorneys. It could be any number more than one. It could be 2, 3, 4, as many as you like. The advantage of having joint attorneys is that it can reduce the risk of abuse if the attorneys exercise independent judgment and they're equally prepared to exert decisional authority. In other words, the co-attorneys are not just rubber stamping the decisions of the person who's taken the lead. One of the disadvantages of power of a joint attorneyship is that it can invite disputes. You know, if you're an older adult and you have a son and daughter who are now adults who didn't get along when they were 6 and 8 years old, and they still don't get along now that they're 56 and 58 years old, and you think you're going to solve everything by making them joint attorneys, then you should think again, because the possibility, even the probability exists that as joint attorneys, they may not agree with each other. And as I've seen in many court cases, they end up in court to resolve their disputes because attorneys, they just can't agree. And finally, making joint attorneys can cause problems where they not only disagree, but they they act against each other. For example, I can think of one case where an older woman with marginal mental capacity, failing capacity, advancing dementia, gave a power of attorney to two people who could not get along, which was her second husband and her daughter of her long-standing first marriage. The one party, say the husband, would put money into a certain place and the daughter would take it out and this husband would put it back and they would end up in court. And so making a joint attorneyship to people who are not able to constructively communicate with each other and aren't able to get along is not a good idea. And it's better to decide who, if anyone, you trust, and to make that person or persons your attorney. Next slide, please. Alternate attorneys can also exist. You could, instead of naming two or more people jointly, you could name them in succession. So you could say, I name this person or this group of people to be my attorney or attorneys. And if that person or those people are not willing to act, then I name this person or persons, and you can go down through a succession. One of the words of caution I give here is that sometimes people name alternate attorneys without realizing that the alternate attorney might actually have to act. In one particularly problematic case, I had a woman named her husband who was expected to outlive her based on their health conditions as her attorney for property, with her granddaughter, who was not well situated to act as an attorney, as her alternate attorney. To everyone's surprise, the elderly woman's husband suddenly and unexpectedly predeceased her, leaving the granddaughter, who had some difficult personal conditions, in charge of her rather extensive estate, and there was a lot of problems. And so when you're naming someone as an attorney, a joint attorney, an alternate attorney, always really seriously consider how that person would perform if they were called on to execute their duties. Next slide, please. You don't necessarily have to have a power of attorney for property. As I said, it's rather like getting married. Getting married is great if you understand what you're getting into and it's something you want to do. But if you choose not to get married, that's a viable choice as well. And not having a power of attorney for property or for personal care in place is also a viable alternative. It may be the best option, because if you can't decide who to give the power of attorney to, then perhaps the best thing is not to give one at all. And what happens if you don't have a power of attorney? Well, there are many other options. One of the options, and we'll speak about each of these, are informal banking arrangements. Some of them are just as inadvisable as a power of attorney in some cases. There could be an income security trusteeship. We'll walk that through. If a person is a resident of a long-term care home, they may just need a resident trust account. There could be a statutory guardianship of property or a court-appointed guardianship of property. These may be foreign terms. We'll talk about them more at length in a few moments. Next slide, please. Under the heading of informal banking arrangements, these are some of the things that we see people do. We don't necessarily recommend them, but these are what often happens in the real world. One is just help with writing a check. Here, a person may have a physical disability, but be cognitively intact. They just need someone to help them write out their checks. We see fewer and fewer checks as time goes by. It could also be help with some other form of bill payment. ATM, and by the way, check writing is less susceptible to abuse because at least there's a paper trail. One thing we would not recommend is having someone do ATM banking on your behalf. We've had clients who have given their bank cards to a so-called trusted person who abused that. Go to the bank machine and take out $300 for me and $300 for you. That happens. And it's very difficult to overcome based on the cardholder agreements with the banks. One thing that could work, because it has a paper trail at least, is to give to another person not joint ownership, but a signing authority over an account. This places the person you've given the signing authority to almost in the position of a trustee, where there's a paper trail. It's clear who did what. It is possibly a workable solution. Something that happens more commonly is a jointly held bank account, which is not recommended unless you genuinely intend the person that you're making joint ownership with to be able to have all the funds. If I can speak personally, my wife and I have a joint bank account, and that's because we each consider the other to be a full owner of the account. If my wife withdrew all the money from our account, I would consider that her legal right, and there'd be no problem with that, and vice versa. But if you're giving a joint bank account to yourself and say your adult son or daughter or some other person, how would you feel if the person withdrew all of the money from the account? Because when you give a joint bank account, that is the implication, that that person is actually an owner of the money. And you should not be doing this unless you consider the person to be an actual owner of the money. There could also be other jointly held assets like title to real estate, which is equally inadvisable. Another alternative could be a bank account held in trust in someone else's name, which, as opposed to a joint bank account or a signing authority, could be a superior option because it has a clear legal mechanism and a clear paper trail. Next slide, please. If someone, an older adult or even a younger adult, is a very low income and has really no financial assets to speak of, then an income security trusteeship may be the answer. It's possible for persons on ODSP to have a trusteeship in favor of someone else. So too with the Canada Pension Plan, Old Age Security, and Guaranteed Income Supplement. There are tens of thousands of older adults in Ontario whose only income are federal income security pension payments, who have no substantial assets. And these people can have their finances managed by someone else acting as a trustee, who would simply provide an application with medical evidence that the pension recipient is mentally incapable. The federal government uses the word incompetent. It can be given to a family member or another person. The person managing the funds would have to make a written promise to use the pension money for the exclusive benefit of the incapable person. And the payer agencies, such as Service Canada or the province of Ontario, can revoke the trusteeship. This wouldn't work if the person has things like substantial bank accounts or real estate or other investments that need to be dealt with, but it could be part of a puzzle. Next slide, please. Here, I'd like to pause a bit longer. What happens if you do have assets, like you own a house or you have an RRSP or assets that need legal authority to deal with, and you're mentally capable one day, but you have a stroke or an accident on the Highway 401, or you gradually lose mental capacity due to advancing dementia, and nobody has a power of attorney for you. What's going to happen? What will happen then? Well, if you don't have a power of attorney, then someone can gain legal authority to manage your finances if by arranging a capacity assessment of your capacity to manage property. You, as the person being assessed, have the legal right to refuse the assessment. You don't have to agree to the assessment. You have to be informed of what the assessment is about, and you have the right to say no. And if you refuse it, then it stops the process. But if the assessment goes through, if some of the capacity assessor assesses you and finds you mentally incapable, the assessor will deliver a certificate of incapacity to the public guardian and trustee. By default, the public guardian and trustee, by operation of statute, this is what we call a statutory guardianship, becomes your guardian of property. They don't want to do that. They also have the legal authority to delegate this power to a family member who applies for it. So, for example, if I did not have a power of attorney for property in favor of my wife, and I suffered a stroke this afternoon, and she needed legal authority to deal with financial assets owned or jointly owned by me, she could arrange a capacity assessment. If I don't refuse it, the public guardian and trustee would have legal authority. They would invite an application from her to take over. She would complete the application and submit a fee and a management plan. And if the PGT approves it, then she would become my statutory guardian of property with full legal authority to make all financial decisions on my behalf. And the advantage of this process over a power of attorney for property is that the public guardian and trustee also has the authority to revoke the statutory guardianship. So if it were me and my wife who both became incapable, and we had given a power of attorney for property to one or more of our adult children who mismanaged our estate, there would be nobody really to stop our children from mismanaging our finances. But if we gave it to none of them, and one or more of them had to apply to the public guardian and trustee, and they mismanaged our finances, then the PGT could terminate the statutory guardianship and resume management of our estates by the PGT without court proceedings, which in many cases would save hundreds of thousands of dollars and much litigation. Next slide, please. The last resort, the nuclear option, this is a third of three options. The first is a power of attorney for property. The second is a statutory guardianship. The third is if none of those are available, then someone can apply to court to become the court-appointed guardian of property for a person. This is a highly intrusive and expensive method. It requires an application to Superior Court under the Substitute Decisions Act, and it can only be created if and when the court finds that the person in question is in fact financially incapable and also is in need of a guardian of property and appoints a suitable guardian. But if all else fails, this can happen. It's rarely done, but it does happen. Next slide, please. Now, no matter how someone gains legal authority to have substitute decision-making power over another person's property, there are some duties, and there's limits on what you can do. And so whether you're an attorney for property or a guardian, either by a statutory guardianship or a court-appointed guardianship, there are some rules. And I'm going to walk you through some of the rules that apply. The first thing is the attorney or guardian has the legal authority to do anything in respect of property that the incapable person could do, except for make a will. You can't make a will. And you can't get married on someone's behalf because that's not a property decision. It only applies to property decisions. And the things that you can do are limited by any conditions or restrictions in the power of attorney document or the court order. And Also, if the person is a guardian, not just an attorney, but a guardian, then the guardian also can have access to information, personal health information about the incapable person. Next slide, please. The fundamental rule for an attorney or guardian is that they are a fiduciary, meaning a person who stands in a position of trust on behalf of the incapable person, and they must exercise their duties diligently and in good faith. Next slide. These are more of the rules. If a person is managing property as an attorney or guardian on behalf of an incapable person, then the attorney has to consider whether the decision has an effect on the incapable person's personal comfort or well-being and take that into account in making their decisions. Next slide, please. The attorney or guardian for property also has the duty to manage the property in a way that's consistent with the decisions made by the incapable person's decision maker for personal care decisions, unless the estate simply won't accommodate that. So if I can give you a couple of different examples, this is a very important rule. So many people who are under a guardianship of property, say a statutory guardianship, are still completely mentally capable of making their own personal care decisions. And so the financially incapable person might wish to make a decision about their accommodation, where they're going to live, which is a personal care decision. And being their own decision maker for personal care, the financially incapable person might decide to move out of a congregate living facility like a long-term care home and move into another arrangement, like say a private apartment. In that case, the decision of where the person is going to live belongs to the person, him or herself, because they're still mentally capable of making their own personal care decisions. And in that case, the person managing the finances then has the legal obligation to make the financial arrangements that are necessary to accommodate the personal care decision. In another case, a person might be mentally incapable of both property and personal care decisions and have really no residual decisional capacity for either property or personal care. And that person may have given different powers of attorney to one person for property and another person for personal care. And so, for example, if I were to give my power of attorney for property to my eldest son and my power of attorney for personal care to my eldest daughter, then their decision-making process would be like a dance, where my daughter, who makes personal care decisions, leads the dance. And the conversation might go like this. Sister, Dad's cash is running a little low. I'm thinking that we need to move him out of the house into a long-term care home. Brother, I'm Dad's decision maker for personal care decisions. I know that Dad loves living in the house and I don't want to move him into the long-term care home unless it's absolutely necessary. I think he should stay home if we can do it. Sister, if Dad wants to stay home, we would have to take a mortgage out on the house. And who knows how long that money lasts? There might be nothing left for his estate by the time he dies. Brother, I don't really care what's left in Dad's estate. I think it's best for him to stay at home. And as long as I'm his decision maker for personal care, he's staying at home. You do what you have to do to arrange that if it's within Dad's means to do so. And that's how that conversation would go according to Ontario law. The limitation, of course, is that it's like the emergency brake. It's, you know, if if it looks like disaster, let's say sister says, brother, dad's been living at home. He wants some fun in life. And dad and I are going to we're going to leave the home and we're going to go together on an around the world cruise for the rest of his life. You finance that. Then brother might legitimately say, well, sister, dad doesn't have enough money to finance that. He'll lose his health care benefits because he'll be outside of Ontario, et cetera, et cetera. And the adverse consequences of you and dad taking around the world cruise the rest of his life outweighs the benefits that would go to him. And I simply can't make those arrangements, in which case you might end up in court for the court to give directions. But again, that's the broad strokes of such a conversation might go. And so sometimes people think that giving a power of attorney for personal care is less important than a power of attorney for property. And they might give it as the consolation prize, give the power of attorney for property to that person you really do trust, and to give the power of attorney for personal care to someone else you love, but you don't quite trust to manage your finances. And that is a terrible mistake, because in my opinion, the power of attorney for personal care is even more powerful than the power of attorney for property. And that's not to diminish how powerful the power of attorney for property is. I think that it's as important as a decision about getting married, and making a power of attorney for personal care is even more so. Next slide, please. Here's a rule that applies as well. The person, the guardian or attorney, must explain to the incapable person what their powers and duties are, even though they're incapable. Next slide, please. And they must not only explain, they must encourage the incapable person to participate in the decisions to the best of the person's abilities. The person might have no ability to participate. They might be comatose, or they might have such an advanced state of dementia that they're not able to understand any information. But the person may be able to participate in the process, and the attorney or guardian would still be the decision maker. But in making their decisions, they should be taking into account the incapable person's wishes. Next slide, please. Oh, this one is a very difficult one for many attorneys and guardians, because the attorney or guardian is required by law, it's a legal duty, to foster regular personal contact between the incapable person and his or her supportive family members and friends. So often when we see abuse, the abuse revolves around isolation, and an abusive attorney will not want the incapable person to have contact with their family and friends. They will want to isolate them. And when you see an attorney or guardian isolating the older adult, it should raise red flags everywhere. Next slide, please. Consultation. The attorney or guardian must not only foster regular personal contact between the incapable person and their supportive family and friends, but the attorney or guardian, him or herself, must also consult with the supportive family and friends who are in regular personal contact, and with the persons who provide personal care to the incapable person. And this is specifically so that the attorney or guardian can make the correct property decisions on behalf of the incapable person, with information about what's happening in the person's life. Next slide, please. When the attorney or guardian is paying expenses on behalf of an incapable person, there are some expenses that are mandatory. They must pay from the incapable person's estate. They fall into three categories. The first category is expenses that are reasonably necessary for the incapable person's support, education, and care. The age group that we serve, older adults, don't usually have a lot of educational needs, but they do have a lot of support and care needs, and they could, I suppose, have educational needs as well. The second category is expenses that are reasonably necessary for the support, education, and care of the incapable person's dependents, most commonly a dependent spouse, although it could be broader than that. And the third legal category is expenses that are necessary to satisfy the incapable person's other legal obligations. You know, like things like rent or utilities are things that are usually in the first category. They're necessary for the person's supporting care, because without paying the rent or the utilities, they're going to get cut off or evicted. But other legal obligations would include things like, let's say, a tax debt that the person maybe cashed in an RRSP without realizing they'd have a tax liability that has been unpaid, or a judgment against them for some unpaid debt or something of that sort. Next slide, please. And so there are guiding principles on how you make these expenses. The first principle is that in paying for the person's support and care, you have to take into account the value of the person's property, their accustomed standard of living, the needs of their dependents, and any other legal obligations. So sometimes we'll see an older adult with failing mental capacity who has a relatively great wealth, but their decision maker, their attorney for property, might put them in substandard accommodation. Perhaps if they move them to long-term care, to basic accommodation with 2 or 3 roommates, or if they're outside of long-term care, we've also seen situations where they moved to very substandard accommodation and had very poor meals and so on, all for the purpose of preserving the estate for the benefit of the estate beneficiaries. And you can't do that. If the person has an accustomed standard of living and the means to support it, then that has to be taken into account in how you arrange their expenses. Secondly, is this triaging of categories. And we have these 3 categories for the person, for their dependents, their other legal obligations. You have to satisfy each category before you move on to the next. So the person managing has to pay for the support and care of the incapable person before they can then pay for the support and care of the person's dependents. And they have to do both of those categories before they can move on to satisfy the other legal obligations. If I can give you a practical example of this, many years ago, I represented an older adult woman whose legally married husband took a stroke and landed up in a long-term care home under the statutory guardianship of the public guardian and trustee. The man was someone who exactly had the situation I mentioned. He had cashed out an RRSP, not realizing that there will be a tax liability, and he had a very large tax debt to pay. And so in managing his finances, the PGT paid for his long-term care fees and his very modest living expenses, no support to the dependent spouse, and then applied the rest of his income towards his outstanding tax debt, until we wrote to the PGT and said, look, we represent the wife. She has a support claim against her legally married husband. And under the Substitute Decisions Act, you have to, from his estate, provide for her support and care before you pay for his other legal obligations. And that was sorted out fairly quickly. So the PGT continued to pay for his long-term care fees and his very modest legal obligations. Then they paid for her support and care as his legal dependent. And after that, there really wasn't any money left on a regular basis to pay his tax debt. And the PGT just had to deal with that there was no money left over. Next slide, please. After paying the required expenditures, if there's money left over, the attorney or guardian can also make optional expenditures, which are charitable gifts or gifts and loans to the incapable person's friends and family. It's allowed to give gifts and loans or charitable gifts under certain circumstances. Next slide, Matt, please. And so as far as gifts and loans, they can only be made, we're not dealing, these can only be made if after making the gift or loan, there's still enough money in the estate to cover all of the incapable person's required expenditures. and there's reason to believe that the incapable person, if they were still mentally capable, would make the gift or loan, and the incapable person doesn't object, doesn't express a wish to the contrary. So if I might give an example I often give, which is a caller to our office had one sibling, a brother, and his father had predeceased them, and his mother was living with advanced dementia, and he was managing his mother's estate under a power of attorney. His parents had owned a business, and they were quite comfortable before their father retired and later died. And as the caller and his brother reached adulthood, their parents gave them each a very substantial monthly stipend to help them out, get established in life. And this varied in amount. It depended on their life circumstances, but it was a pattern made by the parents. And so this continued. And when the caller took over his mother's finances as her attorney for property, he continued to make the monthly stipends to each of himself and his brother in roughly the same amounts that his parents had done during their lifetime or during his mother's capacity. And that's quite allowed under the Substitute Decisions Act because there was plenty of money left to meet his mother's other financial obligations, that it was consistent with what they had done. She had expressed the wish to do this while she was capable, and there was every reason to think that she would continue to do that if she were still capable, and his mother was not objecting. In another case I handled, I acted for an older man who his second marriage was to a woman who was 30 years younger. And when he was 55 and she was 25, it was one thing. But when he was 85 and she was 55, he began to wet the bed and found himself unwelcome in the home. And she, as his attorney for property and personal care, had him placed in a long-term care home, which he did not appreciate. And then while he was in the long-term care home and unable to get out, she made a six-figure donation to an arts group that he had never heard of and had never had any intention to donate to. So there she made a very substantial gift on his behalf using his property that he had no intention of ever making. And not only that, while he was mentally incapable, he objected to the gift, which was not allowed. Next slide, please. Now, if people really understood what they were giving when they give powers of attorney, they might not give them. They might, but it'd be like the marriage question. If you really understood what marriage is, would you get married? Many people would. Some people would say, oh, geez, I didn't realize that. And so too with powers of attorney. And on the other side, if people who accept powers of attorney, who are named as the attorney, really knew what they were getting into, many of them might not do that either, because they're of all these obligations we've seen and more to come. And one of those obligations is to keep records and accounts in accordance with the Substitute Decisions Act of all of their transactions on behalf of the incapable person. And by the way, here we're just talking about property. The record keeping obligations for personal care decisions dwarf these obligations, as extensive as they are. Next slide, please. I'll come to what the record keeping obligations are in a bit, but when you're acting as an attorney, if you are not being paid, there is a standard of care on you to act with the care, diligence, and skill that an ordinary person would do in managing their own finances. So you have some duty on you. Next slide, please. If you are being paid to manage the person's estate, in other words, if you take compensation for acting as an attorney for property, then you have a higher standard of care, which is the care, diligence, and skill that a person in the business of managing property would have to use. So while you're being compensated, let's say a percentage of the person's estate, also you are more highly accountable for any errors you may make in connection with the estate. Next line, please. Next slide. And if you're an attorney or a guardian, you are personally liable in damages for breaching your duty. So if you don't act honestly and in good faith and so on, if you don't keep accounts, if you don't pay the right expenses, you can be personally liable for mismanagement. There is an exception clause. If a court finds, if they're satisfied that you have acted honestly, reasonably, diligently, then it can relieve you of all or part of that liability, but it's still a liability issue. Next slide, please. If you're acting as an attorney or guardian, you have a legal duty to try to locate any will that the incapable person made and to find out what the will says. Why would you need to do that? Next slide, please. It'll come in a second. You also have the legal right to recover any property that belongs to the incapable person, including a will. So if somebody else is holding the will, you have the legal right to recover that and any other of the person's property. So for example, if you're named as your father's attorney for property and your brother has possession of your dad's car, then on your dad's behalf, you have the legal right to recover the car from your brother. And then what you do with the car, well, that's a whole other ball of wax. It's probably not the thing you're going to do to drive it yourself. You may actually probably have to sell it and put the proceeds into the estate, or you might even sell it to your brother, but you have the right to recover any of the incapable person's property. Next slide, please. And here's why locating the will is so important. If you're acting as an attorney for property or a guardian, a statutory guardian, a court-appointed guardian, and you're aware that the will disposes of a specific asset under the will, it gives it to a particular person, then you are not allowed to dispose of that asset except under one of two conditions. One condition is that you have to dispose of the asset to meet the incapable person's necessary expenses. In other words, the support and care of the incapable person or their dependents and their other legal obligations. Or you're giving the asset to the person who would be entitled to it under the will. So I can deal kind of with the first category. Let's say the property is your mom's house. You're acting as your mom's attorney for property, and she becomes mentally incapable. She leaves the house and goes into let's say that the decision is made that the person who's authorized to make her personal care decisions, maybe your aunt, her sister, says, mom's not going into long-term care. She can afford to go into a nice retirement home that meets her needs but costs a lot more, maybe $10,000 a month instead of $2,000 or $3,000 a month. And that's where I've decided she's going. So then, even though the house was left to you or your brother or someone else or all of the kids, you have to sell the house and use the proceeds to pay for mom's retirement home fees. Because there, the proceeds, the disposition is necessary to meet her care needs. Or let's say that the property is again the house, that mom has an unencumbered house that she has left in her will to your brother, who never really had a job, never left home, has really no independent means of support, and has been living with your mom right to the time she goes into hospital. But in addition to the house, your mom has investments exceeding $1 million, and she's left the house in her will to your brother, then if it's abundantly clear that it's not you don't have to sell the house to pay for mom's support needs or of her dependents or her other legal obligations, then it would be acceptable to transfer title of the house to your brother, who is the beneficiary of that gift in the will. If the will says give the house to your to my son who lives there, then you could do that. Or by the way, attorneys are not often really champing at the bit to do this, but it may be something that the law demands. Or let's say the property is mom's wedding ring, and mom has several kids, all of whom are interested in the wedding ring, but the will says that this wedding ring goes to one particular family member. The attorney can't just say, well, look, I'm managing the property. Everybody wants this ring. I can't decide who's get it. So I'm going to draw lots. You can't do that. You can't say, well, I'm going to sell it and just go into the estate. What you could do is you could give the wedding ring to the person who is named in the will. That's an acceptable disposition, but you cannot sell or dispose of the wedding ring otherwise. There's nothing you can do with it. And as long as you're holding on to it, you also have liability for loss or damage to the wedding ring. If between now and the time mom dies, you're still her attorney, and it goes time to distribute her estate according to her will, and the wedding ring is missing, then you might have personal liability under the Substitute Decisions Act for the loss to the estate. So the prudent thing to do might be to give it to the person who's entitled to it under the will. Next slide, please. And here we come back to these record keeping responsibilities. I still haven't got to what you have to keep records to keep track of, but here's how long you have to keep them for. And it's a long time. Well, you have to keep these detailed records. You have to give them to the incapable person if they ask for them. And you have to keep them until, firstly, these are conjunctive. The first part, you're no longer the attorney or guardian of property, and one of these three things has happened. Either somebody who has authority to give you a release has given you a release for your management of the property. And that person could be, if the person has passed away, it could be their estate trustee, let's say. Or your accounts are delivered to the new attorney or guardian or to the estate trustee, or there's a court order authorizing you to destroy your accounts. And that doesn't happen very often. So, these things creep up on you. Some important event happens, you find yourself as an attorney or guardian of property for someone else. Right away, you start paying a bill, and you don't realize that you have to keep a record of that and every other transaction you make for an amount of time that's not limited by years. It's limited by events, and it can go on for a long time. You can be on the hook for quite a while. And this is why I say that people who are named might often not act if they actually knew what was involved in being an attorney or guardian. Next slide, please. Finally, here's the slide dealing with what are the records. This is not the full list. This is a summary. This resembles what a person acting as an estate trustee must keep records of. And, it's the Cadillac or the highest version of estate accounts, probably in the world. In other places, I'm told that, for example, in some courts in England, they have made orders that the person must pass accounts in, quote, Ontario form, because the Ontario form of accounts is so high standard. And this form includes keeping an up-to-date list, not just after a period of time, but ongoing, of what are the opening assets and liabilities at the time you took management. Every asset you bought or sold, like an investment or renewal of a GIC, all the money you received, all the money you paid out, any investments you made, any liabilities you incurred, any liabilities you discharged, and any compensation taken by you. The details are, more legalistic than that, but it's pretty extensive. And the words up to date are important as well, because there are some forms of accounting, such as if you're a director of a public company, then your obligation is to provide audited financial statements at periodic intervals, say every year or 15 months. And until that interval passes, you're never in default if the interval hasn't passed yet. It's not the same for a trustee or for an attorney. Your obligation is to be ready to account at all times. It's rather like a lawyer holding a trust account. We do reconciliations every month by the 20th or 25th day of the month of the following month. But your obligation is to have a current list up to date at all times of all the money you're holding in your mixed trust account. And so too, with an attorney or guardian, your legal obligation is to keep records and accounts that are up to date at all times of all the transactions you've made. It's a very onerous obligation. Next slide, please. As mentioned, you have to keep these accounts, and if the incapable person asks for a copy of the accounts, they're entitled to have that. You have to give it to them, even though the person might be mentally incapable of making property decisions. And also, if there's another person who's a decision maker for personal care, a person holding an power of attorney for personal care, or a court-appointed guardian of the person, they also are entitled to have a copy of the accounts at any time. Next slide, please. If accounts aren't delivered, or if they are, somebody can apply to court to have the attorney or guardian pass their accounts. In other words, bring an application to court to have the court approve your accounts. The people who are entitled to ask for this are the incapable person or their attorney or guardian of the property. A dependent of the incapable person, such as, the incapable person's spouse or partner, the public guardian and trustee, or a judgment creditor, someone who has sued the incapable person and got a judgment against them. Or if the court grants leave, any other person can request an accounting with leave of the court. And here we're talking about the Superior Court. Next slide, please. The powers the court can exercise on the passing of accounts are extremely extensive. They can, if they see problems with the administration of the estate, the court can direct the public guardian and trustee to bring an application for guardianship. The court can suspend the power of attorney. It can, on a temporary basis, appoint the public guardian and trustee or someone else as a temporary guardian. It can order a capacity assessment of the allegedly incapable person, or it can order that the power of attorney be terminated. All of these are within the Substitute Decisions Act. Next slide, please. Here is something that I routinely recommend to lawyers, and on the rare occasions that we draft powers of attorney to clients, which is to include a special provision in the power of attorney for property document that appoints a monitor. In other words, someone who has no financial interest in the older adult's finances, but merely is acting out of, usually out of natural love and affection, or out of professional duty, like say an accountant or someone, and who would be willing to offer oversight of the attorney, supervision oversight of the attorney. Next slide, please. Because without a monitor, if you've lost mental capacity, how are you going to enforce your own rights? And so if your attorney misuses their powers, you call them a rogue attorney. Who reins the rogue attorney in? And someone who's, if you have like a brother or sister or a best friend or a neighbor or someone who sees things going on, but they don't want to get involved, they might not feel in a position to help. But if they were named in the power of attorney document as a monitor, then they might have the authority to hire a lawyer at your expense and to rein in the rogue attorney. Next slide, please. And here's some of the, when I've been asked is, if you're a lawyer drafting a power of attorney document, what are some of the things that you could authorize the monitor to do? Well, here's some of the things I've thought of and recommended is the monitor could have the right to receive the accounts that the attorney keeps at regular intervals, say every month or every 3 months or once a year, something like that. To obtain financial information from third parties upon request on the authority of the incapable person in the power of attorney document. To demand information from the attorney about their compliance with the Substitute Decisions Act. In other words, have you been consulting with the persons who provide care or with support of family and friends? Have you been encouraging participation? How have you been ordering your expenses? The power of attorney document could authorize the monitor to get legal advice with financial indemnity from the estate. In other words, if the monitor goes and hires a lawyer, who pays for the lawyer? Well, the power of attorney document could say that the incapable person's estate has to be available to pay for the legal fees for the monitor if the monitor feels the need to intervene. And finally, to act as a litigation guardian on behalf of the incapable person if litigation is necessary to rein in a rogue attorney. Next slide, please. I think this is my last slide. I'm just going to check my notes. Yeah. And so one of the things that's lacking, of course, at the beginning is a lack of understanding about powers of attorney and adult guardianships by people who enter into them as, the potentially incapable person. But what's also lacking is information and knowledge by the persons acting as attorneys and guardians. And so at minimum, I think that people who are named as attorneys should be given some routine educational materials on what their duties are, the things that are contained in these slides that they should know before they start making those financial decisions, and what their accounting and record keeping obligations are and how they fulfill those. And also, the person who's giving the power of attorney should not be having the same lawyer as the person who's receiving it. If the person named as the attorney or the guardian needs legal advice, they should be going to some other lawyer who does not have a conflict of interest to be getting their own legal advice. And I think those are all my remarks. I haven't left a lot of time for questions and answers, but I don't mind going over if people have the willingness and ability to stay longer if there are more questions. And so I can't see the questions. I'm going to try and look here, and I'm going to ask for Molly's. Molly Rotering is one of our licensed paralegals who works at the Advocacy Center for the Elderly, and she's highly qualified and has a good head on her shoulders. And I'm so glad to have Molly with us, and if she can guide me through.
Thanks, Graham. Great presentation. The first question we've got here is, I need to update my will and complete POAs. Do I need to do this in person, and do I need to supply my own witnesses?
I wish I could give like a yes/no answer to that. I kind of skipped over virtual execution of wills and powers of attorney. And so there are in Ontario, following the COVID-19 outbreak, new rules that allow the virtual execution of wills and powers of attorney. And so I'm going to treat virtual execution as equivalent to in-person execution as long as the rules are being followed. But the bigger answer is, if you have assets that are income or assets that are fairly substantial, this is something that you should not be doing yourself. You should be hiring a lawyer and relying on legal advice to update these documents, because like to be legally binding, a power of attorney always has to be done in solemn form. there is a provision for a will to be a holograph will. In other words, a holograph will is a will that's made entirely in your own handwriting. It doesn't have to be witnessed. It should be dated, because the rules on wills are that later wills usually revoke earlier wills. And so if you don't date it, how do you know when it's made, right? But it is possible to do a holograph will. But a holograph will is usually inadvisable if you have any substantial assets or income. A holograph will could be useful for someone who has no real estate, no substantial savings or investments, who is really living, say, on a pension income and really wants to name the person who will close up their apartment or their whatever living accommodation they have, to dispose of their personal effects and to arrange their burial. That would be a good use for a holograph will. Then you don't necessarily have to go to a lawyer and have a will in solemn form. But for other cases, I compare it to fire insurance on your house. If you own a house that might be worth several $100,000, you might find it expensive and inconvenient to arrange fire insurance, but you would really consider that a necessary cost of homeownership. Or if your roof needed repair, of getting your roof repaired, you would do that. And so too, if you have an estate that includes perhaps real estate and other savings and investments, getting a will done is more expensive than it used to be. It always was a fairly significant expense. But I would really advise getting legal advice paid for by you as a necessary cost of dealing with those financial assets, just the same way it would be house insurance, car insurance, a new roof, or winter tires. I don't know if that answers the question enough, but that's the answer I have.
Terrific. And the other part of their question was, do they need to supply their own witnesses?
Oh, you need to supply your own witnesses. If you're not using a lawyer, then yeah, you got to supply your own witnesses. But if you're hiring a lawyer to do that, that's a private arrangement between you and your lawyer. And so many law firms, if they are retained by you for preparation and execution of a new will and testament and a new power of attorney, would be in a position to supply the witnesses. Many times the law firm will not be in a position, and they would ask you to supply a second witness other than the lawyer or paralegal who would be signing as well. So that's a private arrangement between you and the lawyer or paralegal that you hire to do that work.
We've got an interesting question here. Do you recommend automatic bill payments from bank accounts as a good alternative to a power of attorney?
I do. I recommend a power of attorney when you're absolutely sure you can trust that person and you feel you need to give one. But if you don't need to give a power of attorney, I would rather you not give one. And, if your problem is that you're quite mentally capable of understanding information about your finances, and you're quite mentally capable of appreciating the reasonably foreseeable consequences of making or not making your financial decisions, and automatic bill payment is a convenience that helps you to manage your own finances longer, then I would absolutely recommend that. And in my personal life, it's something I do myself, even though I sometimes feel I have full mental capacity to manage my finances. Please don't ask my wife, because if we went around the room and asked, has your spouse or partner ever done something that you think is completely stupid with your finances, we might find a good response rate on that. But I would recommend automatic bill payment.
We've got two questions here. I don't know if you'll have time for them regarding statutory assessment and statutory guardianship.
Yep.
The first one is, how long would it take for a statutory assessment?
Not long. It could take longer, but to get a capacity assessment, you would probably need to get a list of the capacity assessors from the capacity assessment office at the Office of the Public Guardian and Trustee, and they're fairly prompt in response. I would think that a couple of days to get that list would be more than enough. You would then make a private arrangement with the capacity assessor, and it may take you up to a week, but it could take you as little as a day just to find out the right assessor and make an arrangement. And usually, depending on how busy the assessor is, it wouldn't take long to get the capacity assessment done. The holdup is if the assessor finds the person incapable, in other words, the person being assessed does not refuse the assessment, and a certificate of incapacity goes to the PGT, it would normally take at least several weeks for the PGT to process that. They may invite you or other relatives to apply to replace them, and it would take several more weeks for the PGT to process that application. And so, in the grand scheme of things, if let's say I took a stroke this afternoon and my wife didn't have the power of attorney as she does, and she needed to obtain a statutory guardianship, I would be impressed if she had that whole process completed within 3 months.
And the follow-up question to that is, if the person says no to the evaluation, is that option for an assessment unavailable?
The option is not available. The statutory guardianship is never intended to be a coercive situation, and here, the person doesn't even have to say no. If they indicate that they refuse by some means, that ends the process.
And we've got a question about educational brochures / duties of a power of attorney currently available.
Yes, the Office of the Public Guardian and Trustee publishes that legal information, and so do many private law firms as well. And some of that information is available online. And
the CLEO, the Clinic of...
Yes, CLEO, yes, of course.
They have an excellent brochure as well.
If there are no further questions, I again wanted to thank everyone in attendance for your attendance today. This type of presentation is very important to our clinic. It's the first of, I hope, many, and I'm so grateful to have your time and attention. Thank you.